Hi, y'all, and welcome to tonight's live stream. Well, today at the Karen Reed trial, we had what I'd call a true Perry Mason moment, a moment when everything goes right for the attorney, and the attorney is able to just pull off a big surprise, a really big win in the courtroom. I will tell you from personal experience, attorneys wait years for this and entire careers for this, really. And you often don't even get one ever. But today we actually saw one, and it probably was not the attorney that you would think, because Alan Jackson, one of Karen Reed's attorneys, has done most of the cross-examination. He's had most of the big moments in the case. But today it was Yannetti's turn, and he was Karen's original attorney, and it was his cross-examination that I thought was so strong. So, but let me assure you, it was not all smiles and roses for Karen Reed today. There was serious evidence against her, hard-hitting negative evidence. So just all I can say is buckle up, because the prosecution ride is racing to the end. We're going to start with the phone data and the timeline. And you may say to me, no, Lee, I'm here for the Perry Mason moment. Come on. But that will come second. Trust me, you will not be disappointed because it's just a bombshell day all day today. So you will not be disappointed, and you are not going to want to miss the phone data. And I'm going to incorporate it into the timeline we started last night. And also that leads us directly into the Perry Mason moment. So we're going to get to that. I want to say a special shout out and welcome to the first 5 in the chat tonight. Wonderland Alice, Paige McLean, Sweetie, Cognac Kobo, and Gen X. I think I butchered your name last night. Now that I see it with the capitals, I'm able to tell how to say it. So, okay, well, let's get started, because it was a big day. Oh, I do want to share one thing with y'all, like just as we're getting rolling. I have a new favorite pastime, and that is, if you are watching on one of the feeds for the Karen Reed trial and they have the chat up running, you can do a summary. You can just refresh and do a summary of what the chat is doing. It can be hilarious. Sometimes they're just really straight up, the people are discussing a case involving, and they get it right, but whatever. But sometimes it is just hilarious, and I wanted to just share a couple with you. Let me share my screen with you. So I am about to, just a second. I just decided to do this at the last minute. So let me head over there. Okay, so this is my all-time favorite one. The chat conversation is about a court case where a judge referred to as Bev, that is true, her name is Beverly Cannoni, but a lot of people refer to her as Bev, is presiding over the trial of a man, Jackson, who is accused of dog bites. This is Karen Reed's attorney. And so AI thinks that he personally has been accused of dog bites. Jackson, what are you doing? The chat participants are commenting on Bev's perceived bias, the evidence presented in the trial, and Jackson's defense strategy. And here was another one. The ongoing chat conversation mainly focuses on the ongoing trial of John and Chloe, with viewers expressing their opinions on the case, the witnesses, and the defense and prosecution strategies. So Chloe is the dog who was in the Alberts home. The Karen Reed team believes that the dog Chloe was involved in the attack on John O'Keefe, and explains why he has all the scratches on one arm. But it's not the trial of the dog Chloe, and it's certainly not the trial of John O'Keefe, who is the person who was found dead lying in the snow. So I just thought that was overall pretty hilarious. If y'all do that, every time you hit refresh, it ought to give you a new summary, or at least most of the times. Occasionally it doesn't. Send me the funny ones, because I just have really gotten a kick out of this. So if you get a really funny one, send it to me, and I would love to use it on one of the live streams, or just get a chuckle. That would be nice too. All right, so let us dive in to the first witness of the day, Trooper Nicholas Guarino, who talked about the phone data, which would be things like chat messages, voicemails from Karen Reed. And it was hugely important. He also talked about John O'Keefe's phone data and talked about the movement shown on John O'Keefe's phone, which would include things like steps that he took and any kind of movement. There were that's steps, but also like stairs as well. So we're going to talk about all of that. So let me go ahead and pop up the timeline in this screen. Let me share my screen with you. I will stop sharing that one and add the other one. It's a different program, so I couldn't share it otherwise. So let's pull that up. Why am I not seeing it? Give me just a second. No one panic. Now I'm panicked, of course. Like, wait, I should never have let it go. All right. There it is. Okay. So what I've done is, we're doing a highly color-coded affair here. And so for when there was anything, yesterday we talked about the red. The red is Karen Read and John O'Keefe, and we kind of followed them through the timeline, all the information we've gotten to date at the trial about John O'Keefe and Karen Read and what was going on. But today we got more information about that. So I put that in yellow, so it'd be easy to spot. I'll turn it to red, and we on other nights are going to talk about some of the other colors, what we learned, for example, about Jen McCabe, what we know about the people that Karen Read's team says may be the third-party culprits. That would be Brian Higgins, and it would also be Colin Albert. So we're going to follow all of those through. I'm going to take you through the timeline. So and I need to give a special shout out again, because the amount of help was absolutely fantastic. The paralegals, they're calling themselves, which I love. Meredith Huffman, Jay at Your True Crime Library, Loretta Powell, Judy Ray, Kia Barone, Mayor, Jackie C, Julie Carr, and Heather B all sent me fantastic information, divided up stuff. They are a huge part of this. So I so appreciate their help. And if there's anybody I left out, please forgive me and send me your name, and I'll be sure to get it right next time. Okay, so let's head down and look at what we found out about from what we learned today. So between 12:11, did I definitely not have anything earlier? Because I thought there was something earlier. I guess it's our first. Okay, 12:11 to 12:21, John O'Keefe's phone tracks 170 steps, which would be about 326 feet of walking. I'm going to make this a little bit larger. And then from that, in fact, that 12:11 to 12:21, that is going to be so important, and it's going to be the crux of that Perry Mason moment we're going to walk through in just a minute. 12:12 a.m., John O'Keefe GPS and help data shows he's at the Waterfall Bar. So he's still there, and at some point, the steps are most probably walking out to the car, something along those lines. So then we're going to head on down here at 12:20 a.m. He is, according to the data pulled out by the state, at 138 Dedham Street, and he types 34 Fairview into Waze. 34 Fairview is the address of the party that Karen Read was driving him to. She decided not to go. She says he decided to go on in. But he typed in 34 Fairview into his Waze. Waze is a directions map finding sort of app. And he did it at 138 Dedham Street. This timing is really important because the state says if this is 12:20, then there is no possibility that anything but Karen Read could have killed him. And the reason they say that is because they believe that the steps that were taken later and the stairs that were taken later were just him moving around. It couldn't be him walking into the house. He was, according to the data from the phone, at times around this period, he was walking up and down steps, and he was also doing things like taking just walking steps, regular walking steps. So I should call them stairs. He's going up and down stairs, and then he's taking steps. The fact that he's doing that during this time period, Karen Read's team says that shows us he was still alive, and it shows us he went into the house. The prosecution says, no, you get all kinds of crazy stuff with your app and on your phone, and that's what you have here. How can we prove it? The state says we can prove it because at 12:20 a.m., which is just shortly before the last of these movements happens, he types in 34 Fairview. And so we know he's not there. He's not there yet. So he can't be the one taking, or he can't be actually literally taking stairs. But you are going to see what Karen Reed's team does to try to convince the jury that he still could be. So from 1221 to 1224 is when John O'Keefe's phone shows those 80 steps, 287 feet, and importantly, ascending, descending 3 flights of steps. That would make sense if he walked up the stairs to the house and then walked either up or down, upstairs or downstairs to the basement. There was suggestion from Karen Reed's team that he did just that, and that's where he was attacked. So then at 12:24 a.m., John O'Keefe's cell phone arrived at 34 Fairview, and it's within 3 feet of where the GPS is for the rest of the night. That is a critical moment in time, 12:24. At 12:30 a.m., Karen Reed calls John O'Keefe for 9 seconds. And then at 12:31, his phone shows 36 steps, 85 feet. Karen Reed's team, if he's dead, if she left, how is he doing? How is he walking? How is he managing to do that? So let's keep looking. From 12:33 to 6:03, and I started whenever the earliest time is when I plug it into the timeline. There were 53 phone calls from Karen Reed to John O'Keefe. One at 12:36, Karen Reed's phone auto-connected to John O'Keefe's Wi-Fi network. That is an absolutely critical red letter moment, because at that point, the prosecution witness had to admit at that point, she clearly can't be at 34 Fairview. She must be at home with John O'Keefe. It also answers a question we had last night. We'll talk about it in just a minute. We had wondered, based on what she says about how she's about to leave, if maybe she was driving back to her house. What this shows us is she, at least for this period of time, went back to John O'Keefe's house. But it also casts some doubt on other things. We'll talk about that. But 12:36, the phone call from Karen Reed to John O'Keefe, 0 seconds. O'Keefe's report shows the call is missed. That could be consistent with either side. Either he's being beaten up, doesn't have time to answer the phone, or he is lying in the snow because Karen Reed hit him. Either way, it's a missed call. 12:36, another one. This one, 9 seconds. And Karen's report shows that the call is answered. How does that happen? I can't answer it, but 12:37, a voicemail from Karen Reed to John O'Keefe. John, I effing hate you. Now, why? I think the defense is going to ask, when anyone who had just killed someone and is hoping to get away with it, leave a message like that on someone's voicemail. Wouldn't that be out and out crazy? I suppose the prosecution will say, well, she wised up, sobered up later. And that was when she thought, what have I done? And tried to orchestrate things so she wouldn't look as guilty. So at 12:42, Karen Reed left John O'Keefe a message. Personally, I couldn't hear words. I only heard noise. It was very difficult to hear a lot of these messages. Then the time was cut off on the page we had. We talked about these 4 in a row last night. Karen texted John O'Keefe saying, I'm going home. So she's at his house. We know that much, but she says she's going home. She then texts him, see you later, and then sends a voice message to him saying, and I just couldn't understand it. If any of you were able to hear and understand that at the trial today, please send me what you think it said, because you've got me. There's a lot of cussing in it. That's the only reason I'm not playing it tonight. Last week when I played the Proctor tape, the little bit of what he said and what was read aloud at trial, YouTube demonetized it because of the language. So I'm not going to actually play it for you. But if any of you heard it and know what it said, I'd be curious what you think. I just couldn't tell. It sounded to me like what you see written here, John, I'm killing your effing kids. I don't know. And that was just kind of what I thought maybe I heard, and I just couldn't understand it. But and it didn't seem to make a lot of sense, the words I thought she was saying. Then she texted John O'Keefe just 3 minutes later saying, your kids are cucking alone. At 1:04, texted again, I'm back in Mansfield. The kids are home alone. Now, we know she can't be back in Mansfield if she just said she was going to see you later at 12:55. It's a 20-minute drive. So that isn't possible. And so we don't really know exactly what she means. It could just be she's trying to threaten him. And that sort of comes out later. At 1:10, she calls her mom or dad and there's no answer. So if they're a big support for her, that would be kind of a normal thing to do when in an argument with a boyfriend. 1:18, she leaves another voice message for John. Again, the defense is going to say, who would do this if they've just killed someone? Not only does it make no sense to implicate yourself as someone angry with him, but if you think he's dead, why would you leave a message? Why bother? So, John, I'm going home. I cannot babysit your niece. I need to go home. You are just effing using me right now. Something, you're an effing loser, something yourself. Not what, I don't think it was the word you might think would fill in there. I don't know what was said. It was super hard to understand. But clearly, she was upset. And you can see some reason around that because John decided to go out and party. The daughter is at home and shouldn't be left alone. And Karen Reed feels that. But on the other hand, John doesn't seem to be concerned about it and isn't coming home. So she wants to go home and can't because she feels the responsibility of staying there with the niece. And she's saying, you're using me, which sounds like at least he didn't care a lot about that particular issue. He didn't seem concerned. So 4:40 a.m., she called her mom or dad. And by the way, I think the daughter was pretty old by then, I think 14. So he may have felt comfortable leaving her alone. It may not have felt like it was a risk at all. So she called her mom and dad again, not answered. And at 4:42, called again, and it was answered that time. Then at 5:23, she left a voicemail for John O'Keefe. And by now, remember, she is looking around for John O'Keefe. She's calling people and trying to figure out where John O'Keefe is. And she leaves a voicemail for him. John, where are you? The defense will say that's because she literally didn't know where he was because she had no idea she'd hit him. Or, I mean, she didn't hit him, but that she had no idea if she had hit him, she certainly didn't intend it. So that's sort of the defense argument. Karen Reed then at 6:08, and this is after the body has been found, left a voicemail for him, or at least there was a voicemail on his message machine from her. I cannot understand anything that was said. She started with what might have been my apologies, which seemed really odd, and she's there with his body in the front yard. None of this made sense to me, but if you can read this, I just wanted you to know, or I mean, if you can understand it, please tell me. 6:15, John O'Keefe's phone moves again, but this would be because people pick it up having found him at the scene. This would not be anything he does by that point. So let me, is it right? Yep, there's a little bit more. Now, importantly, one of the things that was argued today was whether or not the prosecution is going to be allowed to put into evidence the fact that at 1:27 p.m., Karen Reed called a potential DUI attorney. They say this shows us she felt guilty. She obviously thought she was guilty. And it shows, too, that she was totally clear that she was very possibly a suspect. She says, that's because Trooper Proctor called me at 1:19. And he called me using his personal cell phone, but I knew who he was or some such. And so that's why I called this potential DUI attorney, because I was concerned. The judge said, I'm going to let that in. I'm going to let the prosecution talk about that, but not right now. It's going to have to come in later in response to something that the defense says. So we'll hear more about that. And at some point in the afternoon, and I didn't catch a time, Karen Reed texted a friend named Laura and said, we found him, John, outside in the snow at 5 a.m. He left a party we were at. I don't know what time. I didn't even go in. I went to bed. And I think the prosecution will say that isn't really true. Not only was it not 5 a.m. that you found him, it was 6. I don't know what difference that would make, but they did bring that up. And also, I think they're going to say, look, these facts aren't quite right because there was no we at the party. Karen never went in. And so, but she does say that. She says, I didn't even go in. So I think that was the final bit of new information. Okay, so let me pull that out. And so I am just so excited about this timeline. I think it's going to make such a difference for our being able to understand and follow the whole case. And it's going to help us also put things together. We can start to see gaps or things where some evidence needs to be put together. We'll just be able to see so much. It's going to really help us go through this. So I have some people to thank, and then we are going to be covering that Perry Mason moment. Also, go ahead and put in the chat, how many of you know who Perry Mason is? Because if you don't, I'm going to change the title of my thumbnail because maybe a lot of people don't even know who Perry Mason is anymore. So my grandmother was crazy about Perry Mason, and I loved the show too. But let's see, it's a TV show. I'll give you that much of a clue. But if you don't know, just go ahead and tell me, and I'll know to change the title of the thumbnail. So Nashe Jones has been a member for a month, and she said she's found the Karen Reed trial so confusing. I think so have a lot of people. I think it is confusing. And that's one of the things I'm hoping with this timeline, we can kind of bring some understanding to it and put together all of the information in one easy to understand format so we can start to see the connections. And Miss Construe has been a member for 2 months. That is fantastic. Thank you, Miss Construe. And let's see, Elizabeth has been a member for 2 months, sending your condolences. Thank you so much. I appreciate that. For those of you who don't know, my husband passed a little bit over a month ago now. So thank you, Elizabeth. Kelly D, member for 4 months, which is the maximum amount of time we've had members for a total of 4 months. So thank you, Kelly D. You're a long timer there, and congratulations on reaching 160K. Thank you so much, and also mentioning George. I appreciate that. Kayla, oh, thank you. I appreciate that. Nice note and super chat. And so I think All Eyes on Delphi, which is a very interesting case, by the way, is talking about missing the GPS showing him going up to the house. You may have just tuned in. I think it's in there. So go back a little bit before where we are right now. And I talked about the steps that he took and that kind of thing. And it should be in there. So that's one of the things that is super important. I completely agree with you that is utterly important. And we have to be able to account for that. And we are about to see the Perry Mason moment when it all happened. And I also want to thank Matthew for gifting 20 lawyerly memberships. Thank you. We are really having a good time with the membership. And we had a members event a couple of nights ago, and that's where we were trying to work on this timeline to present to you so we could have it. And that's where I got great help. And then people went back, they took assignments. You do not have to take assignments just because you become a member, but we did have some volunteers, which I definitely appreciated. Okay, so let's head in to the rest of the testimony. So I am going to remember, let's talk about John O'Keefe and the steps. Remember that the Commonwealth believes that he arrived at 12:24. So they're assuming that everything before that, the steps he took, the stairs he climbed, that's just, moving his arm or something along those lines. And we all know people who do this to try to increase their steps, but that's what the Commonwealth thinks happened. And in fact, they even have a different theory, which I'm about to play for you, for why he looks like he went up steps. So let's go ahead and you will
Pine Cone Road, and then Maplecroft intersects here. And this is the ascending, descending stairs point in his phone. Doing a Google Earth elevation check. There's about a 20-degree dip, and then it goes up. And then as you go down Cedar Crest, the hill is about a 50-foot elevation change again. So it's pretty significant.
And so I'm sorry, sir, as far as the elevation change that you're talking about, how is that measured, and how and where is that in reference to what's depicted up here?
So again, like I said, in this area here, there's about a 20-foot drop, and then as you go down Cedar Crest, that hill, it's about 50 feet. This spot here is the ascending, descending stairs. So As I said before, he doesn't have an iWatch on, so it's not collecting that great health data. It's still acting as a pedometer. So again, whatever movement he's doing is triggering something in the phone as he's ascending and descending these hills. Essentially, it could be tricking the phone into thinking it's stairs.
But on cross-examination, so the witness is saying the reason it looks like he's climbing stairs is because he's in a car that's going up and down hills. And that's causing his phone to think he's climbing stairs. But on cross-examination, Yannetti managed to use the witness to cast some doubt on Jennifer McCabe and some of the other people inside the Albert home who testified. Now, you may remember that they all said they saw Karen's car, or a number of them did. They saw Karen's car when they looked out the window, a dark SUV, and they saw it move a time or two, and it was out there a long time. They all mentioned how very long it was out there. And they said Karen Reed and John O'Keefe stayed out there a long time. That would feed into the prosecution's suggestion that they were having an argument. Maybe they were fighting. He came on in, and that was kind of what happened. So, and we even know that Jennifer McCabe says she texted him. There's evidence of that. She actually texted him to come in. But it must not have been Karen Reed's car that they were seeing, because we now know from the cell phone data and from the admission of this witness that Karen was home by 12:36. So 12:41 is when Buchanan said he saw her car pull into John O'Keefe's house. Well, that can't be right. And 12:42, Jim McCabe is texting, come on in, and that can't be right. So here's what the witness said.
Timestamp is 12:19 and 32 seconds. That's when the phone initially starts creating the GPS points before Waze is activated with 34 Fairview searched. So this looks to be the time Waze is actually opened up.
And so from the purple dots that are depicted on the screen, as far as where is Mr. O'Keefe's phone at 12:19 a.m. in reference to 34 Fairview Road?
12:19 is right here. 34 Fairview is down.
Wait, sorry, I'll have to read it to you. I don't know. I may have it out of order. We'll have to skip it if we do. So here's what the witness said. He said, you testified on direct examination that Karen Reed's phone connected to the Wi-Fi at 1 Meadows Avenue at approximately 12:36 in the morning. Yes, sir. So you can testify based on that by 12:36 in the morning, Karen Reed was not at 34 Fairview, correct? And he says, that's correct. And so we know now, and this witness has acknowledged that she wasn't at 34 Fairview. So when people were looking out and seeing a black SUV at 12:42 or 12:45, it wasn't Karen Reed's. She wasn't the one who was there. And he even went so far as to say, so you would agree with me, no one could have, including Jennifer McCabe, could have seen her at 12:45 at 34 Fairview. As I said, and the witness said, as I said, Karen Reed, auto connects to the Wi-Fi at 12:36. So no, she wouldn't have been there. So, okay, we are now ready for the Perry Mason moment. I have to set it up for you. So they're talking about the fact that O'Keefe's phone records, phone records movement data when, frankly, he shouldn't be able to be moving. Under the state's theory, Karen Reed has to have hit him and knocked him over in the snow and still had time to get home to connect to his Wi-Fi by 12:36. So it has to have happened substantially before that, enough time for her to drive home as well as for it to happen. So how is that to happen? Well, Yannetti is about to blow a pretty sizable hole in the state's theory, but he's going to set it up. He's going to pin the witness down on exactly when the movements were, starting with the steps. And he's going to say, and I'm not sure what part I just played, but the data showed that he took a total of 170 steps between that time period of 12:11 and 12:21. And so he's going to set it up. Let's go.
All the way here, you can't really see, but it's right in the bottom corner.
And the next slide.
Oh, now's the part
This is the same map, but just minus the tracks. The tracks graphic.
Okay. Give it just a second.
You had
There we go.
testified on direct examination that Karen Reed's phone connected to the Wi-Fi at 1 Meadows Ave at approximately 12:36 in the morning.
Yes, sir.
So you can testify based on that by 12:36 in the morning, Karen Reed was not at 34 Fairview, correct?
That's correct.
And that was the first of those voicemails that you testified to, correct? That was the I hate you voicemail?
Yes, that's 12:37, correct.
Okay. And that voicemail and every other voicemail that the jury heard was left after Karen had left 34 Fairview, correct?
Yes, sir.
And except for the one at, after 6 in the morning, the 4-minute one when she went back, we heard that one. But all the other ones were apparently left when she was at 1 Meadows, correct?
I can't speak to where she was, but
But she wasn't at 34 Fairview.
yes, that's correct. She wasn't at 34.
And so you agree with me? No one could have, including Jennifer McCabe, could have seen her at 12:45 at 34 Fairview?
As I said, she auto-connects to the Wi-Fi at 12:36, so no, she wouldn't have been there.
Okay, so now we're at the point where he's going to pin him down on the steps. Yannetti's going to pin the
That will
witness.
help. And the data showed that he took a total of 170 steps between that time period, correct?
That's what the phone registered, yes.
If it shows 170 steps between 12:11 and 12:21, then strictly based on the data, you don't know where those 170 steps took place within that 10 minutes, correct?
To a degree, yes.
Okay. And it's possible it could have been toward the beginning, toward the end, or maybe fairly evenly spaced, right? You just know that there were 170 steps that were taken in that 10-minute time frame, correct?
Again, that's assuming that they are steps.
Right. And again, I'm asking you from the data itself.
Again, the phone says it's steps, doesn't mean they are.
All right. Well,
So,
And now he's going to pin him down on the stairs that we talked about.
the Apple Health data also showed a total of 80 steps between 12:21 and 12:24.
correct.
And you would agree with me that, and again, assuming that they were stairs as Apple Health data reflects, those stairs could have been ascended or descended toward the beginning, toward the end, or throughout that 3-minute time period, correct?
In this case, no, because there's a set point that's in the Cellbrite report that shows it's 12:22 and 14 seconds.
All right. Finally, his Apple Health data also showed a total of 36 steps between 12:31:56 and 12:32:16, correct?
Yes, that is correct.
All right.
Okay, so now the witness is committed to when the stairs occurred and to the idea that the reason he had to explain it away as extraneous movements was he knew John O'Keefe was not at the house yet. So if John O'Keefe is several blocks over typing into Waze 34 Fairview trying to get there, he's not there yet. So this couldn't possibly be John O'Keefe going up the stairs into 34 Fairview because he's not there yet. He's several blocks away. But it's just 3 minutes when you think about it. That is a mighty close call, especially when it comes to sending someone to prison for life. And given how, at least my experience with these is they're not always exactly correct. But so Yannetti is thinking, if I can get this moved 3 minutes, they might be real steps. And John O'Keefe really did go in the house. And so now you're going to see the boom start
Your
to come down.
conclusion was that John O'Keefe could not have been at 34 Fairview Road at 12:22 and 14 seconds because Waze put him on Oakdale Road about a half mile away, correct?
12, yes, correct.
All right. And that caused you to disregard the Apple Health data or to attribute it not to steps or to stairs because he was a half mile away between that 12:22 and 12:24 time period, correct?
Yes, I attribute it to movement.
Are you aware that an app on an iPhone may pull data by choosing from 3 different clocks when it timestamps location data?
Yes,
Are you aware that those 3 clocks can vary in time?
yes,
Sometimes for a matter of seconds?
What do you mean? So
In other words, the 3 clocks could be seconds apart, correct?
I would have to see the data.
All right. And you would agree with me that sometimes the clocks could be off by 3 minutes, correct?
No, again, I would have to see the data.
And he is about to see the data.
And do you see the 3 different clocks that are listed on that printout?
I do.
What are those 3 different clocks?
Sorry, it's a bit blurry. Monotonic date time, baseband date time, and then display date time.
And looking at that, and by the way, do you recognize that as being information that was available from John O'Keefe's phone from the extraction?
Yes.
Looking at 640, is it clear to you that those 3 clocks were not in sync regarding that one process number?
Yes.
In fact, the monotonic clock regarding this particular Waze artifact from John O'Keefe's phone says 2:22 a.m., while the baseband and display clocks have timestamps 3 minutes earlier, correct?
Yes.
So if there's a 3-minute difference between the clocks, well, strike that.
Yes, but I can explain why this is incorrect.
All right, maybe Mr. Lally will ask you.
Sounds
all right?
good.
But you would agree with me if there's a 3-minute difference between the clocks, that could explain the discrepancy between the Apple Health data and the Waze data, could it not?
No.
Now, Dr. Stonebridge, with
Oh,
regard,
and let me go ahead and stop it there. But as you can see, it was, I thought, a super important moment because he pinned the witness down to exactly what he needed. It was 3 minutes, that 3 minutes, and the location where he was, those were the only things keeping him, forcing him to say that this could not be possibly John O'Keefe climbing stairs at the house. And he got that 3 minutes, I think. Now, the witness did have the chance to explain it on redirect, but frankly, I thought it was really difficult to understand. I doubt many on the jury did understood the witness's explanation. The document showed the 3-minute difference, and that is so close, especially when you're talking about different clocks and that sort of thing. So it did seem to me like this was a really successful moment, a huge moment for Karen Reed at trial. And it was excellent lawyering. And I thought he led up to it just right. It was really super well done. And then we had more. We had more from the medical examiners. We got some of the answers we have been waiting for on exactly how the injuries happened. Did they help Karen or did they help the state? We're going to talk about that in just a minute. I have some more people I need to say thank you to. Thank you, Cinderella. I appreciate the super sticker. I really do. And Daniela K., who has been a member for 4 months, one of our long timers here, says Perry Mason is a classic. Well, I'm glad you know who Perry Mason is. I always enjoyed those shows. Probably why I became a lawyer. And we have 2 new members, one new member, Mandy Strong, and Young Black Economist has been a member for 2 months. That's wonderful. I'm glad to have you on board for 2 months. And OCD 123, a member for a month. Thank you for the nice message. And let's see. All Eyes on Delphi. About the weird moment, the trooper would not deny that Canton Police Department was scene of a crime. He may know Proctor took the taillight pieces. So I heard that. I'm not sure, and I understand what you're saying. One of the things that people were talking about in the chat was believing that he was saying he couldn't deny that it was the scene of the crime. I was hearing it a little differently, but at that point in the examination, he was sort of arguing with Yannetti, and it was really hard for him to start to admit things. What you just saw, that what I consider to be Perry Mason moment, and I may have a low standard, but I know how hard it is to get that moment and how rarely it happens in law. But I felt like he was just being argumentative over an issue. I didn't feel like he was saying that was the scene of a crime, but there were a lot of people in the chat talking about it, so I know what you're saying. Mandy Strong is talking about her phone saying it moved around her home when it hasn't budged. I've had that experience too. And I've also had the experience where you're sitting there and suddenly it updates and it looks like you're literally sitting, but it'll suddenly say that you just walked 100 steps. And what they're referring to is it updated in a chunk of time. So I do think there are some issues there. Okay, so I'm going to thank Zero Patience. I appreciate that. And Nina Brown. And then I'm going to pop back over into, I've got more people to thank, but I want to go ahead and get back over here to the case and to the two medicals. They were medical examiners. We have been waiting for one medical examiner, but we got two today. Dr. Stonebridge focused on neurology, the brain, which it certainly was a huge issue for John O'Keefe, and Dr. Scorti-Bello did the primary examination. So we heard from both of them, first from this witness who was highly controversial in the chat. When she testified, everybody was talking about the witness and less of what she was saying, but she was a really good witness in terms of her ability to talk and explain.
To your findings, you mentioned that your findings were that the injuries were acute and that the injuries were the result of trauma, correct?
Yes.
What, if anything, can you say or can you opine as to the mechanism for those acute traumatic injuries?
It was something that required some type of force, given that there were skull fractures. I can't say what type of force or how much force, but it was definitely something that caused some type of force, which led to the skull fractures and then the subsequent brain findings.
And the brain findings in particular that you made, were those consistent with the fall?
They can be, yes.
Can they also be consistent with being struck by a vehicle and then going to the ground?
Yes, they can be.
And then we have one more.
Let me hold up before we start with Dr. Scorti-Bello. So unfortunately for the state, if you will recall, the cause of death, was it the manner of death? I get the two mixed up, was undetermined according to the medical examiner. So you may remember that when we had Trooper Proctor on the stand and we talked about that, Trooper Proctor wrote to another trooper, and the other trooper was giving him a really hard time saying, wow, you really messed up. How could you let the medical examiner say it was undetermined? You should have had her say homicide. You really messed up there. And he said, oh, he was just ribbing me and giving me a hard time. But boy, in the text messages, Trooper Proctor seemed pretty defensive. He seemed definitely to be worried and concerned that he did not get a determination from the medical examiner that this was homicide. So that's one of the things that the witness talked about. She talked about why she said it was undetermined and what that meant.
Manner that we call undetermined. Some jurisdictions, they call it could not be determined. That means that evidence pointing towards one set of circumstances or one manner is no more compelling than evidence pointing towards another manner of death. So if we don't have enough information to know whether something, or to be able to determine the circumstances, then we are left with an undetermined manner of death. I am not making a legal determination. I'm making a medical determination.
Give it just a second. It'll queue up.
What did you list as cause of death on Mr. O'Keefe? With regards
Sorry,
to
I had it on high
Cause of
speed.
death was blunt impact injuries of head and hypothermia.
And with reference to manner of death, what, if anything, did you list on Mr. O'Keefe's death certificate in relation to manner of death?
I listed could not be determined.
And as far as that listing for could not be determined, if you could explain to the jury why it was that you have that listed as manner of death with relation to Mr. O'Keefe.
Again, the cause of death is something that I can determine by the autopsy. I did the autopsy on Mr. O'Keefe and determined that he had injuries to his head as well as signs of hypothermia. So the combination of those two was the cause of death. The manner of death has to do with the circumstances under which Mr. O'Keefe sustained those injuries. And I did not have enough information to be able to determine whether those injuries were accidental or not. And so my manner of death was undetermined or could not be determined.
If you could explain.
So at this point, though, the witness did give some specifics, and know that when I do these, I cut. So sometimes you'll see some cuts. I'm trying to keep it the general point of what they said, but try to make it short enough so that I can contain all this in one show. So she's going to talk about those blunt force injuries and what they were and where they were.
The jury sort of what you understand that to mean as far as what is a blunt.
It's not all
blunt
going to be this fast. I'm
Blunt
sorry.
force injuries are caused by any blunt object. That is a very big category of objects. A microphone could be a blunt object. This bottle, if heavy enough, could be a blunt object. The ground can be a blunt object. So anything that doesn't have a sharp edge or a razor edge, not a knife, not a scalpel, is a blunt object.
Give it a second.
The majority of the blunt force injuries
There we
were
go,
to
slower.
the face and the head, as well as to the upper extremities, the arms.
Now, starting with Mr. O'Keefe's head, what was it specifically, or where was it that you observed blunt force injuries to Mr. O'Keefe's head?
Okay. I observed a number of different injuries on Mr. O'Keefe's head, starting with his eyes. He had hemorrhage or bleeding on the upper eyelids of both eyes, as well as swelling of the eyes. He had a small laceration, a small tear in the skin on the right eyelid, again associated with the bleeding. He had some abrasions. Abrasions are superficial scratches on the skin on the left side of his nose, I believe. And when I looked at the back of Mr. O'Keefe's head, he had a laceration. The laceration on the scalp that I observed was overlying the area of the skull that appeared to be fractured, or at least appeared that the fractures were originating from that point of impact and extending into the rest of the skull. Well, there were multiple fractures, so by definition, multiple fractures in multiple chambers or parts of the skull. So I would say they were extensive.
Okay, let's pull that out and I'll just talk to y'all. So that what she talked about doesn't necessarily rule out either side. Certainly it gives Karen Reed's team some fodder. I mean, his eyes were, there are pictures available. His eyes are swollen. He looks like he's been beaten up. There's no other way to describe it. But the witness explained that part of, or one result of getting a head injury can be that your eyes swell up and that you appear just like he appeared. So the fact that he had those injuries doesn't mean, she said, that he was beaten up. It could mean just that he had a head injury. But how did he get that? And that, of course, is the primary injury that he received. And that's the big question. So he could have gotten his skull crushed in by someone in the house wielding something, a bat or something. He could have gotten it by being thrown and hitting his head on the ground. So the witness isn't giving us the final answer. That's going to be left up to the jury. That's the exact thing that's left. She does say a skull is really hard to fracture. It's very thick. And so not necessarily something that would be easily done in a fight. This is a significant crush. She said the one thing she said, I think, that really did help Karen Reed was she said, I didn't see any major signs of what I would call a significant altercation. So that, of course, goes with the state theory that this wasn't a fight. This was John O'Keefe being hit. So we also got a ruling, and then I'm going to take some questions. We got a ruling on the expert witnesses. Remember, we went all the way through that when the attorneys did that argument on Tuesday, and Dr. Marie Russell testified about, just to the judge, no jury was present, but she talked about the dog bites and scratches that she believes are on John O'Keefe's arm. She explained her background and why she thinks those scratches, those marks, came from a dog. They look just like a canine injury, and she would know. She's written multiple papers about injuries from dogs, and she's a medical doctor. So one of the things that the state had done, or the Commonwealth was move to keep Dr. Marie Russell from testifying. Said she was named too late. and also wanted her excluded for other reasons. But in this particular case, the judge said, I told you I didn't want to exclude her entirely. I'm not going to. I'm going to let her testify that those injuries look like dog bite, dog scratches. But what I'm not going to let her testify to is what she talked about on the stand, which is not only does it look like a dog, but it really doesn't even match the idea that this is something that came from a vehicle. This is not what it would look like. She mentioned road rash, taillight scratches, vehicle strike. The judge did. She said, I'm not going to let the witness talk about any of that. The witness is going to have to just talk about the scratches, the dog issue, and nothing else. But she's in. And that, I think, is huge, huge for Karen Reed. I thought she was a really interesting witness, and she seemed very qualified. Who knows how she'll hold up on cross-examination, but I thought she could be a very, very important witness for Karen Reed. Dr. Wolf, she allowed in, but she said she had some concerns about the third witness, Dr. Rentschler. She said that in the state of Massachusetts, biomechanics experts can't talk about medical matters. So she's not excluding him, but she may keep out part of his testimony. She'll make a final ruling next week. That would be a significant deal. Both of those witnesses, Wolf and Rentschler, were very qualified, and in terms of their ability to testify and to talk about matters. She's saying that his scope might be a little too big, might not be something that this witness should be allowed to talk about. So we'll get a ruling on that next week. So we are about ready to take some questions. Let me go ahead and look through the chat over here, through the super stickers. Thank you, Mama4. I appreciate the super sticker very much. And Cindy has been a member for 3 months, and she loved Perry Mason, Matlock, and Murder, She Wrote. Yes, I love all of those. Loved Matlock. Debbie Blair, member for 2 months. Glad to have you, Debbie. And Mandy says, this is true, Mandy, you have been a member since day one. I don't know why I would say you're not. You're right, you have been. Well, welcome for 4 months. Beth from Arkansas, thank you. I appreciate it. That is exactly one of the things I aim to do, is be really fair. If there's a case that really cries out for that, it would be this case, because there is so much contention. And I think people really want to know the facts. People would like to make a reasoned judgment on what the actual facts are. So thank you. I appreciate that. Nina, thank you for gifting Lawyerly memberships. I definitely appreciate that. And is Mama 4 again? Was it a mom of a different number? No, it was Mama 4. Thank you so much. Oh, she's a new member. That's what the deal is. Thank you. Mama Pinks, group hug for Jersey Jen. Okay. Well, of course, we will gladly give out a group hug for longtime member Jersey Jen, and Tammy Areola is a new member. Fantastic. Okay, so let's get started on the questions. I'm going to head over here. And oh goodness, I forgot. Mama, I see Mama Pinks reminded everybody, but if you would, please put question marks at the beginning. It's really hard to spot them as the chat moves by so fast. So if you put question marks, I have a much better shot at finding them. So if you put it in without the question marks, try again. Let's see if I can more easily spot it. Okay, here we go. All right, Tommy. If a juror has 35 years as a nurse in the ER and has seen lots of dog attacks and low-high impact auto versus pedestrian, can that juror share opinions in deliberations? So the juror should not act as an expert. But on the other hand, every juror brings in with them their past experience, which is exactly why lawyers ask so many questions in voir dire, because if you get someone with medical experience on the jury, then you know that everyone else will be looking to them for their thoughts. Just like if you get a lawyer, everyone's going to ask the lawyer, what do you think? What do you think about the legal issues? Do you believe that he's guilty? There will be questions like that, because people cannot help but bring in who they are, including information they know if they are a nurse. They just know that. Okay, looking for the question marks at the front. Jean asking, what do you think about Karen Reed talking to the press outside of court? I find it really interesting because I don't think she'll testify. I don't think she should testify, but she is talking to the press. I think that Karen Reed has an unusual understanding of the importance of social media and of appealing straight to the public in a trial like this. I think her knowledge of that is what has gotten her to a stage that almost every other defendant would not be at this stage right now. So I think it's, I would I want my client doing that? No, I would be terrified. I would be terrified that they would say something wrong. But she's been very careful in everything I've seen to just say, finally getting our story out, something bland like that, but keeping that connection going. So I think it's worked very well. I would be terrified, but yes. Jay Lee wants to know about the lower bite from the dog's teeth. So probably well, first of all, we're going to actually see Dr. Marie Russell at trial. So you can hear more about what she has to say about that. There will be cross-examination on all of that. We don't know all the answers to that yet because she just gave little bits of her testimony. You can go back and watch the show I did 2 nights ago, and I gave a little summary I played a summary of what her opinions are, but there will be true cross-examination when it comes to trial. So that we will find out. Does she believe there is a lower bite? Does she think it just hit a certain way? We don't know the answers on any of that yet. Chris wants to know, why can't the scratches come from a previous fight between Karen and John O'Keefe? I guess they could, but there's been no testimony that they were ever physical. And in fact, the testimony has been that they weren't, that the way they treated each other was definitely, they were never violent with each other. I think it was the nephew who said that if Karen Reed got mad at you, what she would do is ignore you or not talk to you. She would never be violent or angry like that. Gingy Probs wants to know, have you ever had a murder case without a finding of homicide as a matter of death? Does it have a big impact? It does have a big impact because if the medical examiner couldn't figure out if it was a homicide, I think that the jury thinks, wow, well, maybe there isn't an issue here, but I'd really put it on its side first, which is if there is a finding of homicide, I think that's very persuasive to the jury and sometimes overly persuasive to the jury. I think in the Troconis case, for example, there was a finding of homicide. And I think that sometimes that may persuade a jury on their ultimate decision-making. Honestly, that probably rarely should be a finding. Beth A., many people don't accept the conspiracy theory. Does the defense really need a cogent alternative theory, or would poking holes in the prosecution's case be enough? That's a great question, Beth. And the answer is that it would be enough to poke holes in the prosecution's case. And think about why. Because the question that will be answered is whether or not there has been a sufficient showing that she is guilty beyond a reasonable doubt. So if they can't prove that, she doesn't have to show someone else was guilty. She doesn't have to prove she wasn't guilty, just that the jury ought to have a reasonable doubt. There's a reasonable reason to think she did not, and that's all that it'll be. Anna Banana, why do you think the defense is saying they only need a few days for their witnesses? I think because they don't have all that many witnesses, and they'll be probably fairly efficient with them. They've got several experts, but we've already heard from dozens of witnesses. Who else is there? You may be wondering. I'm wondering who else is left. So I don't think that they need all that much time because of the fact that so much has gone before. Their cross-examination was a large part of their case. They don't really truly start their case when they put their first witness up. That cross-examination has been them speaking to the jury, to us, telling us what they think about the testimony. So there will be more to come. I think they suggested maybe 4 days for their witnesses. I will say too, it's unusual for defendants to have very many expert witnesses because they're really expensive, and therefore only people who can afford it, or if there's some kind of payment from the court allowed, it can be very difficult. In the Delphi murders case, that has been an issue because there's been a difficulty paying for expert witnesses. They went to crowdfunding. Momo Shark wants to know, will the defense be able to ask the medical examiner on the intimidating text? I don't know. The medical examiner, I don't think, will be asked about the text messages per se. And I'm assuming you mean the ones where Karen spoke to John O'Keefe. I would think not. I would think she's going to be limited to what she's talked about in terms of the medical side. That's what she says. I'm here for the medical. I'm not here to decide who's guilty. I'm not here to talk about what the emotions are or what the motives are. That's not my role. I'm a doctor. I talk medicine. Okay. And Chris is asking me, did you know Kathy Bates has a new show in the fall called Matlock, kind of after the Matlock? Loved Matlock. I am so excited about that. That's fantastic. And let's see, loves my angel. If the manner of death is undetermined, how is anyone being charged with the crime? Well, it's still within the jury's purview to be able to decide that even though there was, even though the medical examiner can't tell whether it's an accident or whether it was homicide, the jury can, because the jury can look at the facts surrounding it. The medical examiner is supposed to look at the body, and there are things they look at in the surroundings of, for example, the area where the person is found that might be included. But that's what they're focused on, is the body, the medicine, the medical cause of death. They're looking at that sort of issue. And in this particular case, the manner of death is something that the jury could decide separately. It's not so much manner of death. They can decide whether they believe beyond a reasonable doubt Karen Reed has been proven to do this exact crime. So it's just sort of different. They have different roles. That's probably the best way to put it. Let me take a look. A few more people to thank. Retired Rachel, thank you. I appreciate that. And Mickey Bassett, I watch you on 4 different sources and my membership only shows up on the iPad I signed up on. Well, I'm glad it showed up. Thank you for being a member for 4 months. We are not, somehow some lucky channels get a join button on the iPhone and we don't get our join button. You have to actually go onto the computer to join. I've made a request that we be allowed to have a join button. I don't know what you have to do, or, maybe you have to be really big or something to merit that. Jersey Jen. Yes, is thanking everybody for the love and support. And we do all need it. That's the truth. And Lawyer 2 is a new member. Fantastic. Glad for all that. Okay, couple more questions. Let's see what we've got over here. Looking for the question marks at the beginning. Oh, there we go. Mark Chandler wants to know, how do we know Dr. Russell's qualifications are legitimate? It sounds like she wanted to be on police TV. And Mark, that's what cross-examination will be for. With some time, one of the reasons that the judge gave this opportunity, and she said this much, she gave this opportunity for the voir dire was not just for her to make the decision about whether or not these witnesses would be allowed, but to make sure that the state was given all of the information it needed so it would be ready for cross-examination. The state also can look things up. She says she wrote these papers. Did she? And the state can look it up. She says she went to this school or that school. The state can research that and figure it out. So those qualifications will be tested. If the state doesn't raise them, it's probably, I doubt seriously it's because they didn't bother to check. I would think it's because they checked and that wasn't going to be a good area of cross-examination. They were going to have to do something different. And I'm sure they will have other things to talk about when we come around to the cross-examination. Terry wants to know about why did they dislike John O'Keefe? A lot of people are asking that, Terry. What would be the motive for the people in the house to kill John O'Keefe? And just in order to sort of give the jury some satisfaction there, the defense has thrown out a couple of people that it says have motives. Colin Albert, with a motive that would include some long-standing feud with John O'Keefe, and Brian Higgins because he was interested in Karen Reed. You may not buy that. You may not think that that's any kind of good motive or that they've sufficiently shown that. And then you are still left with the question, why did everybody want to frame John? Why did everyone everybody want to frame Karen Reed for killing John O'Keefe, and why did they want to kill John O'Keefe? That's still an issue that has to be resolved in their minds. If not, it does not have to be resolved for them to rule, to make a decision in the case, but it is something that they are, just practically speaking, going to want to answer and think about. And that's why the defense is trying to provide that. Farmer asking about evidence that Lally has presented of Karen's guilt. And, you know, clearly that's going to, one of the things we'll do when we go through the timeline, we'll talk about each of the different, breaking out all the people, what the evidence is around them. But I think there's a huge dispute here. And there are people who think there's nowhere near enough. And there are people who think there is a gracious plenty of evidence. So that will just have to be decided by the jury, and it will remain a source of debate for a good time to come. Vox Waya is asking me, have you ever seen a witness for one side realize during the testimony that it fits the other side's argument? That happens all the time, actually. People will start talking about something and then realize, oh, wait, whose side am I on? And that, you know, it reminds me of when your kids play soccer when they're really little. And one time, one of my kids, I won't even say which, I'm sure that this child would be very upset, but they kicked a goal for the other team. They got confused about which goal was which. And that can happen to a witness too, when it comes to actually getting on the stand and all the excitement. And sometimes they realize, wait a minute, I've run off the deep end and I'm helping the other side. So yes, that does happen. Watchdog wants to know, how did Karen hit him when the Commonwealth says it happened at 12:45 and the Wi-Fi shows she was at John's house at 12:34. I don't think it, and I can't remember the exact numbers either. We've got them in the timeline. I don't think she could have. I don't think that's possible. I don't think in the end that that's what they're going to say. I think they're going to say something a little bit different from that. Senna Girl wants to know if the defense is limited in time to present their case. I don't think there's an official limit, like you only have 5 days or X number of hours. Sometimes judges do that. I don't like that. I don't think that's appropriate, but I don't think that's the case here. The defense has just said they thought it would take, I think I heard them say about 4 days. And the judge has told the jury repeatedly, you're getting the case by the end of next week. We're on track for you to get it by the end of next week. So we know that she thinks adding together whatever the state tells her is left and adding that with whatever the defense is telling her they need and rebuttal case after that, she thinks all of that can be done by the end of the week. So that's still to come. Okay, here we go. Sky Go Des, thank you. I appreciate that. Well, I think we will be back tomorrow night at 7 p.m. I want to thank our moderators, Marlon and Mama Pinks, with a big group tonight. I know they have been really running, trying to deal with everything. Thank y'all so much for what you do. I appreciate all of you, and I will see you tomorrow night at 7 p.m. Eastern for Friday's testimony.